Jane, thank you very much. It's a pleasure to be here. We're delighted to be opening the panels at this event here in Abu Dhabi. And let's get straight into it. Let's begin by reflecting on the trends that we're seeing in our businesses and the developing risk profiles in the ESG space. And Zainab, let's throw it straight open to you. What are you seeing from your clients, and what are you seeing when you, as a shareholder, talk to management in the companies you invest in?
Good morning, everybody, and it's great to be here. It's great to have this as an opening panel to discuss such an important topic. Look, in recent years, we've all seen the ESG investment trade sort of take the world by storm, pardon the pun. Certainly started by European investors and regulators, really taking the initiative there, especially in Europe, but also in Australasia and Canada. And there's a spectrum of ESG demands and implementation as they go through that journey. In the Middle East specifically, I think we're all aware of some of the risks that are facing this region as governments try to diversify their economies away from hydrocarbons. And it's important to point to climate-based risks in particular, like changes in long-term oil demand, for example, changes in water scarcity or rising temperatures. So I think we've seen governments at a high level really try and implement initiatives around these risks and try and diversify the economies. And a lot of these initiatives are really filtering down some of our clients in the region that are primarily state-owned investors, so sovereign wealth funds, central banks and the like, that are trying to really look at their portfolios from an E, less so from an S, and possibly the G has always been there to some extent, you can argue. So Invesco is a large asset management study. We're committed to kind of the state-owned space. We publish a yearly study looking at sort of investor behavior amongst global sovereign wealth funds. And last year, we have found that Middle Eastern investors in particular are paying closer attention to sort of climate-based risks in particular. 50% actually of Middle Eastern sovereigns are looking at this a lot more closely within their asset allocation in their portfolios. I think if you look at the portfolio level, climate-based risks affect real estate holdings. That's sort of an obvious one. But I think from a risk perspective, you're looking at they're really looking at, say, the crowding out of their assets as the ESG trend takes hold across Europe and the rest of the world, and the impact on the valuations and the portfolios on those assets. So that's from a risk perspective. And then from a return perspective, as sort of long-term owners of capital, looking at future-proofing their portfolios, looking at what's really generating return, that's also driving kind of considerations of the E in particular. And that's come to the fore a lot more after the pandemic as well, which has been interesting to see.
Yeah, that's very interesting. And Nasreen, what about from your perspective as a representative of a service provider in the region? How do you see the risks?
Yeah, I mean, as Zainab said, I think that the sort of the demand aspect is clearly accelerating across both issuers and investor side. So HSBC also kind of does a little survey, and year on year, 2021 versus 2020, we saw the issuers reporting impact of ESG factors on their businesses going up by 50%. So there's already a huge acceleration of sort of the focus from an issuer perspective on this subject. And the drivers are many. I mean, actually, interestingly, the number one driver is employees themselves. So employees working for companies want the companies that they work for to do something about social good, environmental good, and to consider the impact they've got on the world. Obviously, regulators, very important driver as well, and there's been a huge focus from regulators throughout the world, including in the Middle East, on this subject. And then finally, you've got clients, whether it's consumers, whether it's investors, clients across the range of the real economy and the financial services economy are interested in this and are obviously driving demand. The risk aspect, obviously, that comes with all of this demand is, there's a generation of product, there's a desire for product. It's the greenwashing risk that's kind of pervasive and that all the lawyers are worrying about. And when we look at greenwashing risk, I think it's really important to look at it through the different lenses. So one lens that is really important to all corporates is the sort of firm-based lens, right? So our own disclosure as a corporate has to be relevant, it has to be accurate, it has to be verifiable, and it has to be fit for purpose for the longer term, right? To sort of assess the longer term impact of whether it's climate risk or other factors, social issues on our economic outcomes, right? So that's something that is really difficult in a world where there is very little consistency and convergence, I think, in terms of reporting standards and also in terms of data. The second lens on greenwashing is the product itself, right? So whether it's a sort of a green fund, you have to explain how are ESG factors integrated into decision making. So I think that's something that's really important to investors. But even on the kind of financing side, you know, our labeled products, whether it's green bonds, green loans, and so on. Right now, there are some industry-level standards, but, you know, do they meet the mark? Will they stand the test of time tomorrow? If you look at, for example, the EU taxonomy, which set certain criteria for greenness, a lot of what's out there probably doesn't meet that mark. But I think these are I think greenwashing is obviously the key risk that we see in respect of the product that we're putting out, for which there's a huge demand.
Yeah, there's a lot that resonates in there, and Paul, probably a lot that resonates with you and your clients as a private practice lawyer and a dispute specialist. I mean, how are your clients thinking about ESG risks and responding to those?
Yeah, no, thanks, James, and good morning, everyone. I think the first thing to sort of say, ESG is obviously a very, very wide topic. And I think, as they know, so at the moment, the focus is probably more on the E than other aspects. I mean, growing on the S and always been there on the G, but with COP26 last year, and obviously COP27 being in the region in Egypt later this year, and 28 here in the UAE the year after, I think there's a growing focus on E in this region. If I think about the sort of categories of risk that are being managed by our clients, I think I'm probably sort of taking a sort of even a bigger step back across the sort of spectrum of clients. I guess they're looking at risks in 3 or 4 different categories. The first is, I guess, sort of direct claims against them, whether that's by an NGO, an activist shareholder, employees, issues to do with sanctions for breach of regulation. The third is just a sort of general reputational risk, whether that is for claims that have been brought for sanctions, for breaching regulations, or just more generally for being seen to conduct business not in the proper way. And then the fourth sort of emerging category, which I guess covers the 3 to a certain extent, is claims by competitors, or particularly in the sort of greenwashing sector that Nazreen was talking about. In terms of what we're seeing our clients do, I think as this topic gets greater hold, it gets more sort of traction in the boardroom, we are seeing clients take a more proactive approach to managing ESG risk. But that is still quite difficult. I think there's necessarily a certain element of reactive handling of these risks, just because the landscape is changing so constantly. And Nazreen was mentioning the sort of evolving regulation, the fact that you don't have uniformity of regulation across different jurisdictions. So trying to sort of keep on top of the regulations you're dealing with in the different areas you're working is very difficult. And we've also got, I mentioned a moment ago, that claims by NGOs, by activist shareholders, looking to sort of hold companies to account for their conduct. I think probably in the sort of carbon area, if you like, one of the sort of most talked about developments in recent times was the claim in the Dutch courts against Shell, where the Hague District Court found that Shell was obliged to lower its emissions and take steps to do so quite significantly by 2030. That obviously has a direct impact on Shell. There's a potential precedential value, although I should say that the case is being appealed. But even before that, the NGOs have been reaching out to other players with interest in the Dutch market. That they wrote to them all in January, I think sort of 20 or 30 companies in January, saying, right, you've got until April. Tell us what you are doing to manage your carbon emissions. And that's not just what you personally are doing, but what is your supply chain doing? And then just sort of coming back to your question, if you think about what clients are doing proactively to managing risk, it's exactly as Zain and Nazreen have talked about, sort of looking at their business as a whole, looking at their supply chain, looking at their counterparties, looking at the whole portfolio now and trying to sort of horizon gaze and what the future landscape is going to look like, and do as much as possible to ensure that you are complying with regulation, you're keeping on top of regulations. And it's also just talking to stakeholders, trying to be aware of what they're trying to, if not preempt the actions by the actors groups, by the NGOs, at least understand what's on the horizon and try to address that in advance.
There's a whole package of issues there,
Yeah.
I think. And I'd really like to turn it over actually to Laurence. Laurence, perhaps you could share your thoughts as a leader and sustainability leader within your organisation. How are you reacting to what really I think is an unstoppable global trend towards ESG risk management and the way we think about it? What are you doing internally and in your organisation?
Yes, good morning, everyone, and thank you very much, James. Indeed, sustainability has been at the heart of the bank I represent, BNP Paribas strategy, for a number of years now. And I have to say that at the inception, lawyers were not so much involved on these matters. However, the legal and regulatory landscape has considerably and very rapidly changed. We see, for instance, a wave of regulations. We just mentioned the taxonomy regulation at the EU level, but this is clearly a global trend. And I know that in the UAE, there are good progress that are being made as well. And regulation is seen as an accelerator. But we also see an increase of legal risk that are at stake. We just mentioned some legal actions, and more of them are brought before courts related to ESG matters. So I think that this reflects also the high expectations from the society based on scientific progress, definitely, but also a clear sense of emergency on this field. So whether we are working as a lawyer in a regulatory authority, supervisor, in a law firm or a private commercial company, I really think that lawyers have a key role to play to advise their business, help them navigating this very complex landscape, but also help them to anticipate and prevent legal risk and draft meaningful regulations or contracts. So we see two important success factors for lawyers in doing so. And the first one, I think, is upskilling. And I'm happy to share as well the experience we have in this field. Indeed, sustainability is really a new field of expertise for lawyers, and it's a complex one. We need to update all our legal knowledge. There are new industry standards, new regulations, new case law, but that we are used to do it, to update our legal knowledge. But on the other hand, we also need to understand the ESG issues at stake. We are not expected to become scientists, fortunately, but we need to have the necessary knowledge to understand the impact of ESG on ourselves and on our clients. So what does the E cover? What does that mean to transition to carbon neutrality, for instance? What does the S and the G of ESG encompass? What are the main stakeholders, regulators acting on the ESG agenda? So all these questions need to be well known by lawyers as well. And we then apply this ground expertise to basically everything we do with both internal and external stakeholders. So within BNP Paribas, a training program has been implemented to develop ESG pioneers across the group. And this was done in particularly with the Cambridge University Institute for Sustainability Leadership. And more particularly for lawyers, I'm glad to say that BNP Paribas is now launching a Sustainability Academy at Ligon that is really dedicated to lawyers in order to provide them with training on ESG matters, but also on the group's sustainability strategy and on all the legal sustainability related matters. So in order to understand ESG regulations, knowing more about the main features of ESG transactions or products, we mentioned green bonds, sustainability linked loans, green deposits, etc., but also raising their awareness on ESG legal risk. And the second success factor, I think, is to position lawyers within business line and making sure that lawyers are really involved in the decision making. And this can only be done with a strong support from the senior management. It is indeed essential that lawyers participate in governance committee, in the strategic discussions, to be able to raise awareness on potential legal risks. So I really think that overall, lawyers have here a great opportunity to develop a new area of expertise and build agile and efficient business practices, yet avoiding greenwashing and ESG-related controversies, as it was mentioned. And this also, of course, resonates with growing needs among the corporate world and employees for a sense of purpose. So to conclude, I think it is clear that this is also a good way to attract talented young lawyers and nurture their commitment to serve their business' own ESG ambitions.
Well, thank you very much, Laurence, and thank you for raising the topic of upskilling, which I'm sure many of us have faced the challenge of bringing together different disciplines and moving away from traditional expertise, whether it's transactional or disputes focused, and thinking about these issues in a way that's much more holistic, which I think is really what's demanded. And it sounds like some absolutely fascinating initiatives that you've undertaken that I think will be very informative for all of us in how we think about upskilling ourselves. Let's change tack just slightly and talk about the different stakeholders who are at play when we think about ESG issues. And we all know that ESG issues attract interest from a wide range of stakeholders, and we've mentioned a lot of them already, whether it's shareholders or activist shareholders, interest groups, employees, NGOs, regulators, and there are more. It seems to me that some of these constituencies present more obvious risks in terms of disputes arising, and Paul, you've alluded already to the role of NGOs in bringing the climate litigation in the Netherlands and applying litigation-focused pressure to different organisations there, and activist investors may be in a similar position and perhaps more likely to dig into their litigation toolkits to achieve their ends. And I think that leads us into a topic I'd like to pick up with everyone about what the role of these different groups of stakeholders is or should be in upholding ESG best practices across organisations, and how much we should be leaving in the regulatory sphere, where regulators are making some progress, but I think face some tensions between the ease of doing business and not over-regulating, with possibly some demand, and people may have views on this, some demand from industry about having clearer guidance and clear goalposts on the direction they should be moving in. And how other actors should influence change, how NGOs or private litigants should influence change. Nasreen, let me bring you in there. How do you think of the role of a lender in this area in driving ESG impact? Is that something that you think a lender should be feeling responsibility for, or slightly less, and how?
I mean, I would put it as not necessarily just in the world of responsibility, but actually opportunity, and I think that it's not actually an exaggeration to say that the transition to a low-carbon economy, I think, is the biggest opportunity that the world will have in this generation, for sure, right? From a kind of economic prosperity opportunity, actually, not just from an important issue to solve for the world and try to limit the impact of climate change. So the opportunity, obviously, for investment and for funding this enormous revolution, I think, is huge, and I think that's where banks and the financial sector plays a huge part, actually, in capturing that opportunity. I mean, in the Middle East in particular, I think the opportunity is so well aligned with the overall reform agenda and the remarkable economic agenda that's there in these economies. So, at a macro level, obviously, oil will continue to be a big input into the prosperity of this region. And I think actually that's fine. It's not in any way contradictory to the fact that this region will also transition and continue to thrive in a low-carbon world, right? Because, I mean, one thing that's kind of from a metrics perspective that people are looking at increasingly is, in addition to just bare carbon emissions, right, there's also carbon intensity. And the Middle East, for example, is already, from a carbon intensity perspective, one of the best regions in the world, actually, if not the best, in terms of our oil and carbon-related products. It's also on a huge transformational agenda in terms of blue and green hydrogen, and other sectors as well, to both adapt, to mitigate, to reduce pollution, to drive sustainable industry, green economy, sustainable agriculture. You know, there's a huge alignment, I think, in terms of the kind of responsibility and the need to mitigate climate and ESG risk generally, and the kind of the vision and the economic projects that are underway already in the Middle East. So the opportunity here, I think, is huge. And, you know, I'm thinking His Excellency mentioned with regards to technology, right, the need to actually adopt technology and put it to good use. And I think it's the same in terms of sustainable finance. You know, in sustainable finance, I think we shouldn't be afraid of innovation. We shouldn't be afraid of supporting these sectors. And as I say, the way that we see it is it's an enormous opportunity. It's a key strategic pillar for us. We feel that our business will thrive if we actually capture this opportunity. And so that's what our focus really has been on.
Yeah, thank you. That's a very interesting set of insights, and putting it as an opportunity, I think, is absolutely the way to think about it. And I think of the 50th anniversary of the UAE last year and the progress made in 50 years, and looking forward to the next 50 years later on is I'm fascinated to hear about, and particularly perhaps how some of the ESG factors and development towards a low carbon economy will feed into that. So yeah, some really interesting discussion yet to come as well. And Lawrence, let me ask you about the challenges of managing different stakeholder groups. I mentioned a few of them. There's a real diversity there. How do you think about managing all those diverse interests?
Yes, indeed, you mentioned the diversity of them, and it's true that a bank, like any other company, needs to manage expectations from all these different stakeholders. And usually most of them expect companies to do more, to have a positive impact on the environment, on the society. And in this context, it's interesting to note that non-financial commitments are useful tools for companies to build their sustainable corporate strategy by committing to take actions that go beyond regulatory requirements. And we have a good examples with all the net zero alliances that have been taken. However, companies must really be mindful that even though those are taken on a voluntary basis, they create expectations, and as such, they can be used against the company in case of failure to deliver, similar to mis-selling, for example. Therefore, companies really need to take meaningful commitments, and only when they have strong enough assurances that they will be in capacity to implement. And similarly, there is also an important pressure from regulators themselves, including on financial market participants. Regulations may indeed help to ensure a level playing field, to achieve harmonization, to fight against greenwashing, and ultimately help achieve national and environmental and social objectives. And the EU has positioned itself as a front runner in this field with the taxonomy regulations that we mentioned, but there are other regulations as well that oblige financial actors to disclose how they integrate the ESG risk in their investment decisions, but also how they take into account the ESG preferences of investors. However, what we need to emphasize is that today ESG data, methodologies, metrics, that the financial actors need to comply with all these regulations, with their disclosure obligations, are not yet available. And in such context, it is important to accompany the public reporting with clear explanation, and that was also mentioned earlier. We really need to explain how we use the data and how we publicly report them. But we also need to work with our peers, with industry, with regulators to develop common standards to help us in this field. As mentioned earlier, there is also a growing ESG trend on legal actions brought by NGOs against private companies as well as governments. We saw in the Netherlands, the Uganda case, or in France, even the case of the century. Though only a very few of them are successful for their claimants, it is really important to monitor them very closely, as they may help us to detect some global trends and anticipate as well legal risk. And one of the trends we see that is interesting is that NGOs are using more and more the duty of care as a legal ground for action. I think that Paul mentioned the Shell case. It was the case in the Netherlands. In this case, they use the duty of care principle in the Dutch law. There are similar laws in France, in Germany, and very soon at the EU level. And basically what it means, the duty of care law makes for companies to have enact a plan to prevent their ESG risk resulting from their own operations and their entire value chain. So you have similar rules, though more limited in scope and less detailed in the UK and in Australia, for instance, with the Modern Slavery Acts as well. So those regulations are important because they usually apply to corporate, but also to all their subsidiaries worldwide. And another trend that I think is interesting to see in some jurisdictions is the use of the principle of science attribution. As the science evolves, it becomes definitely easier to establish, a causal relationship in law between a defendant's greenhouse gas emissions and harmful impacts that were caused or exacerbated by climate change. And this is ultimately, of course, used to establish the responsibility of the emitters. This is a trend that we see in some jurisdictions, and overall, we may see some degree of forum shopping, where claims are brought in jurisdictions that are perceived as claimant-friendly. So that's why it's so important to monitor all this trend. And I think it was mentioned earlier, continuous dialogue with all our stakeholders, investors, shareholders, employees, regulators, but also NGOs, is absolutely essential to manage all this legal risk.
Well, thank you. There's a lot to think about there, and perhaps, Zainab, I can bring you in to share your thoughts on the role of long-term investors and what they are and maybe should be doing in this space.
Yeah, absolutely. I mean, the role is very important and a massive one, of course. There's tens of trillions of dollars of assets sitting behind a lot of these large institutional investors globally. And we've seen some of the notable ones in Europe really take a stance towards decarbonizing their portfolios, signing up to very large initiatives like the Net Zero Asset Management Initiative, which Invesco is a part of. And really driving some of that change. Now, in the Middle East in particular, a lot of these sovereign wealth funds are future generation vehicles, right? They are long-term holders of capital. They are long-term asset allocators, and they are in perfect position, I think, to really drive some of those assets towards more sustainable initiatives. And we have seen that. As I said earlier, I mentioned kind of future-proofing their economies and investing in some areas of technology that kind of are really akin to this space. They are, specifically sovereign wealth funds, do not have explicit liabilities, and so they're not hampered like other institutional investors, public pension funds, and maybe defunded schemes in the Western world. So young populations are really help that effect a lot. I think, we've seen them drive their portfolios towards that. Central banks in particular, and we've seen that trend globally, joining things like the Network for Greening the Financial System and looking at ESG from a sort of financial sustainability or price stability mechanism as well. Now, for us, what we really believe at Invesco as an active house, and we do provide some passive sort of products as well, is that engagement is really part and parcel of this conversation. It really needs to be less about exclusion and more about engagement with these companies that we are active shareholders in and bondholders as long-term providers of capital. And we have sort of tried to influence it as well in the fixed income space. And I do think in the fixed income space, this is going to be the kind of sleeping giant as a lot of assets are held in that space. We do believe in kind of engagement versus exclusion and in integrating ESG issues into our investment process. So we talk about risk, return, and responsibleness. So 3D investing as a lens. And so we're passionate that we do feel like a lot of these long-term investors need to look at it in that lens as well and look at the long-term picture.
Right, thank you. And Paul, we've heard a lot of really interesting insights on managing different stakeholders here. For you, what's the role of litigation and dispute resolution as a tool for managing ESG responsibility and driving ESG change?
Yeah, sure. I think we've already talked about the fact that regulation is still very much developing in this area, still looking to achieve a degree of uniformity. And I think at the moment, I think for the foreseeable future, litigation has a real central role in helping to sort of shape the landscape on ESG issues. And we've already talked about, in particular, NGOs and activist shareholders. And for them, I think litigation is really a key item in their toolkit for helping to shape the agenda. And so what we see is NGOs, for example, financing, funding, and driving claims that are not being brought in order to claim a particular compensation or particular financial reward. They're being brought to establish or emphasize points of principle. Probably one of the sort of most famous examples is the case in Germany of the Peruvian farmer that brought claims against RWE for claiming compensation for RWE's contribution to climate change and the impact that had had on his farm in Peru, which sat below a glacier that was melting and impacting his ability to farm. Now, actually, that also sort of picks one of the points Lawrence made about forum shopping. I mean, you might ask, what has activities of RWE in Germany got to do with a farm in Peru? And that's indeed one of the issues in the case. And again, Lawrence mentioned it, it's establishing that causation. But putting that to one side, the courts have felt there is an arguable case, there's a case to be heard. But the compensation there is because at best, RWE can be said to be responsible for a tiny fraction of overall climate change. And that's the way the case has been framed. This individual was claiming a tiny fraction of the losses he said to have suffered. So the amount being claimed is a few thousand euros. The legal costs are in the millions. And what it's really about is the NGO driving that case to try and establish that these sort of carbon majors or energy companies are responsible for the damages caused by climate change when they are held to be responsible for that. And historically, a lot of the claims we've seen have been, first of all, it was claims against governments. Then it was very much claims focused in the fossil fuel industry against carbon majors, energy companies and the like, and direct claims against those, in particular for their alleged impact on climate change. What we're seeing more and more is indirect claims being brought against financial institutions, financial investors, looking at the indirect harm caused to business by ESG risks. And so the claims cover things like or allegations that the organization have failed to properly manage the risk exposure to ESG risks, or that, come back to Nadrine's point about greenwashing, that they failed to live up to these sort of very public commitments that they have made to adhere to certain standards. And so the claims are brought in a number of areas. The sort of portfolio risk, are you properly managing the risk in the portfolio? Disclosure, are you properly disclosing the ESG risks and the risks that they have against your portfolio, against certain investments? And then we're seeing securities litigation. So you're selling these products on the basis that they are going to comply with certain standards. They've got certain green credentials. If they don't live up to that, there's a sort of there's a misrepresentation or equivalent claim there. And really, disclosure and reporting is an area where we're seeing, I think, greater emphasis being placed, and we're seeing NGOs drive claims in that area, or activist shareholders. So there was a case last year in Australia against Commonwealth Bank where investors sued and were granted access to the private documents within the bank, so that they could then look at those documents and assess the extent to which the bank was complying with its internal policies around environmental and social issues. Again, in Australia, there were claims following the awful forest fires last year against ANZ Bank, which is one of the sort of leading financiers to the fossil fuel industry in that region. Claims accusing them, and these were not in the courts, these were claims brought under OECD guidelines against they had these sort of national contact points in each country. So there were claims brought to the national contact point, effectively alleging that ANZ had not properly lived up to, or was not complying with the spirit of the Paris Agreement. Now, no determination of that, but you can see that the pressure and the focus that puts on on ANZ's business, and there was a similar case a few years ago against ING in the Netherlands. Again, putting pressure on them, and they ended up coming out with making undertakings to put measures in place to ensure that their portfolio comply with the Paris Agreement. They agreed to pull out of coal by 2025. So you can see how these claims by NGOs, even if not in the courts, are really driving change. So I think litigation is, for the time being at least, a key tool.
I mean, I just wanted to kind of follow up on that. I mean, I think you're right. I think that disclosure standards and then the follow-on litigation that's kind of trying to hold the corporates to account definitely plays a role in accelerating, I think, awareness, focus, and drive towards real change from an ESG perspective. But I do think it's sort of there needs to be a caveat, because I mean, if you and it's difficult in this space to really assess the long-term success, I would say, of focus on ESG factors from an investing perspective, and I'm sure Zainab knows all about that. But I think, so for example, I was reading a piece of research that we've put out that looked at some of the studies on a longer term, and disclosure alone is not a big factor in economic outcomes in connection with ESG, right? So the more successful things are, for example, actual increase in diversity, actual integration of ESG factors into economic decisions, management of climate risk, et cetera. Those things are really kind of impacting the longer term economic outcome, which is what we all want. Disclosure alone isn't actually doing it. And so while I understand that the activists want to focus on disclosure because it's the visible piece of sustainability and they can frame some legal arguments around it, I think over-focus on disclosure alone, and both from a regulatory standpoint and from a litigation standpoint, isn't a successful strategy. We need to leave space for this industry to develop. We need to leave space for the opportunities to be captured, right? So that actually there can be meaningful change for the benefit of everybody, right? So,
I agree with that, and it seems to me in looking over towards Europe and the UK in particular, the disclosure piece often gives the hook to bring litigation, and I'm thinking of the UK cases about parent company liability, and there have been a couple of Supreme Court cases in the last few years where the legal theory is that parent companies owe duties of care to people affected by the activities of their overseas subsidiaries. And in one of the cases, for example, it was to do with a copper mine in Zambia, and there were allegations that the mine had polluted local watercourses and affected the population. And the claimant sued both the English parent and the local subsidiary in the English courts, and they need to sue the English company to get English court jurisdiction. And Lawrence, that goes to your forum shopping point, I think. I assume there's a feeling that there may be a better outcome or greater settlement leverage or greater scrutiny via the English process, greater disclosure in the technical legal sense, perhaps. And those claims are based on public statements that the parent companies make in their CSR reports or their annual reports, for example, often in quite generic terms about ensuring high standards through the group and managing the group on a central basis and so on. And the English courts have accepted that could, in theory, create a duty of care to avoid environmental harm caused by the downstream subsidiaries. And that seems to me to have really opened the door for claims against investors, as you referred to, Paul, for how they manage their involvement in their portfolios, as well as the supply chain type claims where it may not be a shareholder relationship, but one of supplier and customer between a company and its business relationships. And also I think it chimes with other European developments, and Laurence, you mentioned the French duty of vigilance earlier, and there's a host of similar cases in the Dutch courts, among other places, and the EU as well is legislating about accountability and supply chain oversight. I think it's a really quickly developing area, and there's real litigation risks that spring off that disclosure issue, even though, as you say, Nazreen, I'm not sure disclosure is the economic answer or the right driver of change. It is the key for the activists, the NGOs who are looking to drive change through litigation.
Yeah, and it's from a risk management point of view. Everyone is being pushed to establish their green credentials, to emphasise their green credentials. Then you're held to account for, as you said, every statement you make. I mean, we were sort of talking off, sort of, a different level. There's been cases in the UK recently, or not cases, but the Advertising Standards Agency has been sort of banning adverts because they've overstated green credentials. So someone had put that the product was 100% recycled, and then in a footnote at the bottom saying, well, apart from the cap on the bottle, it was there, in the small print, whole advert gone. Someone else had advertised saying, buy our product, it was innocent smoothies, buy our product and help make the world a better place, or worse that effect. Banned, because, well, no, but that implies that you are proactively, if you buy this product, there's going to be a positive impact, and there's not. So, as you say, you've got to be so careful about what you say at a time when you're being pressurized to say more. It's very difficult.
I think there's a degree as well of, in some instances, the greenwashing piece and the green claims piece almost being used offensively by, and I mean that in the attacking aggressive way rather than the other way, but offensively by competitors to attack their competitors' advertising campaigns and products and so on. There's certainly been cases like that in European jurisdictions, and that's a whole different lens through which people look at these issues, I think, that's a different conversation. But I don't know if anyone else on the panel would like to share any final thoughts, and then we'll open it up to the delegates.
I guess just one final thing for me. It's important to remember it is a journey. And yes, while you're going to have things like greenwashing at the beginning of this, disclosure is important. I think transparency is important. There's a whole host of regulation, and taxonomy is something that we talk about in the industry a lot, and terminology. And I think as soon as these things are sort of classified and people have common standards around this, and Europe is obviously leading the way in terms of regulations there, then we can get to a better place. But it's important that there are steps being undertaken, however small, and hopefully we're not too late.
I think there's a long way to go on the regulatory issues. Europe announced the S and the G pieces of the taxonomy regulation just a few days ago, and so even there, it's still very nascent, I think. Yeah.
I mean, I think when you come to sort of technical standards, right, so even on the E piece where there is a large body of science and modeling, or the EU, for example, did have to delay the application of the technical standards from its compliance perspective, because it's actually really hard to, even on a European level, kind of get consensus and to kind of give sufficient guidance to the market on what is expected for it to comply and disclose. And so I think that taxonomies are very important, but again, it's fantastic actually that Europe is leading the way, because I think that they are setting a high standard that everybody will have to meet. I think that how the world responds, for example, in the Middle East, I think it'll be really interesting to see, because we don't want to dampen innovation, right? And also, I think what might be suitable in the context of a quite mature and sophisticated European economy may not be suitable in the context of emerging economies, right? So I think there's an interesting kind of journey ahead of us, I think, to see how all this plays out.
I think it's just on the journey, it's worth sort of emphasising again the point that Nazreen was making earlier about the opportunities here. And we've talked, this is a sort of it's a dispute resolution seminar, we talked a lot about risks. And certainly when we started talking to clients about this topic, it was always about risks. More and more so, those conversations are about the opportunities. So yes, it's about managing the risk and mitigating the risks and making sure you're doing the right thing. Yeah. But actually, it's also that there are huge opportunities here that I think people are going to be able to sort of grasp in the coming years.
Yeah, very much so. Laurence, any observations from you there?
Yeah, I fully agree with all what has been said. I think indeed it's I completely agree. I think regulation is important. Definitely, we need to be mindful of all the legal risk, but absolutely agree that this has to be seen as well as a business opportunity, and we should not discourage innovation and the development of new good practices. Everything will not be perfect. We know that. We lack data. We lack some regulations as well. And you're right, the taxonomy regulation is taking time because it's very, very technical, but definitely it's important to find the right balance to make sure that we still can innovate, because this is the only way we will be able to have a real positive impact.
Thank you. I guess at that point, we'd love, you've all been listening to us very patiently, and we'd love to bring our esteemed audience in and hear people's reflections, questions, whatever you may have. I think there are some roving microphones, so if people do wish to raise their hands, please go ahead. The gentleman over here, thank you.
My English is very bad, but I will try to. You know, this big question about sustainable problematic and ecological impact and the ecological impact. I don't know in law that it will be have only one law for every country. What I listen, maybe it's a problematic definition in a country and a solution in a country. But when you même in Europe, give example of Europe. Europe gives to all countries, European countries, a global periphery, a global area to move. But every country in Europe will have his own law. And for example, justice in France is very different than Italy, than Spain, even fundamentally. It means with the judge, we don't have the same way to resolve the problem. And when for example, I give my traduction for my business technical work. I am a legal expert, but in France, it's not good. I am not. I don't know the law. I am what we say in France, the technical of the judge. It means when you have a technical problem, the judge. He is a man of law, a woman of law, not for technique. Then he use people like me, expert in his technical work, to explain the problem between parties. Then a solution in a country will be different than another country. I stop here.
It's a very good point. And Paul, I don't know if you'd like to comment on that. You must have done a fair bit with experts and judges who may or may not be familiar with subject areas in your time.
Yeah, no, sure, thanks. And thank you for the comment observation. I mean, first of all, completely, you're absolutely right. Claims being brought in different countries for the same issues are very likely to have maybe not a different outcome, but you might get there through different means. I think there's probably a number of sort of comments to make. The first of all is that, as Laurence was mentioning earlier, in terms of the litigation that we're seeing, there are many different ways in which claims are being brought, and that's very much driven, as you say, by the laws in different countries. So a cause of action in France might look very different from a cause of action in the UK, might look very different from a cause of action here. So to a certain extent, the litigations that are being brought are very much driven by the legal systems in which they are brought. And as Lawrence again mentioned, there's an element of forum shopping to choose the forums where you have the sort of best chance, I guess, of success on the relevant cause of action. The other point, when we talked a lot about regulation and the growth regulation, at the moment what we have is a real sort of patchwork of regulation, and it's developing at different speeds in different jurisdictions. I think what we hear in talking to clients is that, I mean, no one expects a completely homogenous global regulation. I completely agree that's not going to happen. But I think what you typically see as things get more developed is certainly degrees of similarities, and clients want to get, or companies want to get to a position where if they're operating in multiple jurisdictions, they can put in place a sort of standard set of policies and procedures and be comfortable that those policies and procedures, perhaps if they go to the sort of higher standards in each area, that they'll see them being compliant in each jurisdiction. And I think we're away from getting that level of standardization, if not, if it's never going to be homogeneous, level of standardization in regulation. And the third point, just where you started around sort of sustainability and assessing sustainability or compliance with sustainable credentials, and if you think about sustainable financing in particular, that's not really a question of law, that's a question of the sort of KPIs that are put in place as part of the financing. And again, that very much started out almost on a sort of transaction basis. But now we are seeing more in the way of external bodies coming in and having a standard set of KPIs that are then assessed externally. So we are seeing a development in that area. As you said, it's more in the accounting sort of field, a way of assessing compliance with, or a standard set of KPIs, and then a standard approach to assessing compliance with those.
I mean, and I'll just say something. I mean, you're right, and I think that there will never be, nor is there in any space actually homogeneous laws and regulations across countries, and that's just not how the law works. But I think that, notwithstanding that, I think there's two things that institutions can do in response to that. International institutions, for example, like HSBC, is one. We can't look at compliance to the letter of the law. We have to think about kind of principles, particularly as the law and the regulation isn't even there in many places, but also because we're dealing in an emerging field where there is a need for innovation. So we really just need to look at principles, I think, and that's where our focus has been, is, for example, in terms of a taxonomy, in terms of our disclosure, you have to also have established some baseline principles. And these are pretty simple. You want to be transparent. You want to be clear. You want to ensure that the customer knows what they're getting. There's some pretty basic principles that you can apply that can give you comfort that, even if you're not meeting the kind of the letter of the law, you're setting a standard that's actually sufficient to meet future requirements. I think the other one is through industry bodies, so things like the TCFD, the TNFD, all these industry conglomerations where competitors and peers are coming together to come up with standards, whether it's for disclosure or for product, that are consistent and that address the market need. Those are another really good way to kind of achieve some convergence without this ultimate legal convergence, which we're never going to get, I think.
Yeah. Let me ask Laurence as well. Actually, you must be managing a whole patchwork, as Paul put it, of different regulations, probably even within Europe and even among jurisdictions that theoretically are working from the same baseline. Do you have any observations on how you go about handling that?
Yes, absolutely. It's true that within BNP Paribas, we are looking at all the regulations, in all the jurisdictions where we operate, so globally, and it's true that we are facing a difficult period because we have very different regulations everywhere. To come back on the point that was mentioned on the European legal framework and how it works with judges, I agree that today we have differences, but I'm quite optimistic that we will come to more consistency when the regulations will enter into force. For the time being, they are not yet completed. So we have a part of the taxonomy regulation, but not yet the full taxonomy regulation. All the regulations this year and the next few years will come into force. So I really hope that we will come to a more harmonization. And you know that in Europe, we have the European Court of Justice as well, that is in charge of making sure that we have common interpretation across Europe at least. But I fully agree with what has been said. We need to we won't have global standards, unfortunately, except we have the TCFD, TNFD, and I agree we should definitely encourage the use of these international standards. And otherwise, I think that it's important to try to, as international group as we are, to try to ensure that work with regulators to call for more consistency and alignment as far as it's possible. But definitely lawyers will need to manage with all these differences. And one solution that was mentioned that I think is indeed very interesting is that as a global group, we will apply very high level standards everywhere. So we will apply these global principles in any case. We won't be able to, we won't necessarily look at each regulation. So we will need to have consistency within our practices.
Very much. And Zainab, would you have any thoughts there?
No, not much to add beyond that.
Yeah, quite good set of answers and good discussion. Any further thoughts or questions? A couple up here, perhaps the gentleman at the back first, and then the gentleman here.
Thank you. My question relates to holding the corporate parent responsible for the actions of a subsidiary. Outside of the environmental area, had the UK courts ever done that, pierce the corporate veil, so to speak?
So it's extremely rare, and the recent cases have been in the environmental area. So the two cases that went to the Supreme Court focused on the mining pollution caused by the copper miner, and the other one was to do with an oil spill in Nigeria, in which actually the defendant was Shell, who seemed to end up, unfortunately for them, on the receiving end of a few of these claims. Otherwise, the English courts generally follow what you would expect to be the principles of division between corporate entities and respecting the corporate veil. And the theory here isn't so much that the veil is being pierced. The theory is that the parent is independently liable for negligence in failing to discharge a directly owed duty of care, although the end result is very similar. But it's a quickly developing area, and it is moving in that direction. Paul, I don't know if you have a comment on that, or if you see the same.
No, I'd echo your comments, James. Yeah.
I mean, I think the UK Modern Slavery Act, though, is an area, though, as you say, it's not necessarily piercing the corporate veil, but it is establishing a duty of care at the, at a kind of extraterritorial level for actions that you take. Now, it's focused on supply chain, but I think equally, it effectively it sets a duty of care for a corporation all the way through its value chain, actually. So, I mean, I think that's an area where it's not environmental. It's obviously on the social and kind of labor practices, but it's a developing area where I think that the duty of care is expanding for sure.
Yeah. And let me just ask Laurence, because I think the French duty of vigilance works in a similar way.
Absolutely. So yes, and I think it was one of the first national law that dealt with this duty of care principle applied across all the supply chain, all the value chain of a company, and it was really following, the scandal of the Rana Plaza in Bangladesh that we adopted this regulation in order to really make the parent company responsible for all what could happen within the supply chain and the subsidiaries. And the French law expressly applies to the headquarters as well as all the subsidiaries across the world. That's indeed quite new in the civil law principles. However, I have to say that in the financial for financial actors, it's not completely new because we have a lot of regulations that apply to the group on a consolidated basis. So that means that we need we are responsible for setting procedures, setting good practices across the group, so across the subsidiaries. What was really new here was really the extension to the supply chain.
Thank you. And there was a question from the gentleman at the back there as well.
Yeah, hello. Wolf van Kumberg, I'm a trustee of CEDAR, the Centre for Effective Dispute Resolution in London. CEDAR was really at the forefront of bringing mediation to the UK 30 years ago. And so we're spending a lot of effort and time at the moment looking at ESG and how we can find alternatives to adjudicative forms of resolution here. And as we've already heard today, and as that gentleman also explained it, national courts really aren't the solution here. I think a lot of the NGOs and the other activists are looking at courts because they have no other alternative. And so what we're really looking at here are other alternatives, much like mediation perhaps, where you can bring many stakeholders to the table. Perhaps things like facilitated negotiation as well, conflict avoidance boards, but a forum where you can bring others to the table rather than simply the parties within a litigation. So I think we have to think outside of the box here. Just as we have a lot of developments on the technological side that will be occurring, we also have to find a way to find other means of resolving these disputes other than courts. And so certainly we're working on that, and hopefully others will be doing the same.
Well, thank you. And litigation can be a blunt tool at times, and sometimes people want that because it brings the publicity and the focus on the issue. And other times an organisation may be genuinely trying to drive change in a way that's not confrontational. And Zainab, as an active investor, you may find yourself in that position. Do you have any thoughts?
Yeah, absolutely. I mean, this is part and parcel of sort of governance practices, and we've always, as an active investor, as you know, have been a part of those discussions in our engagement approach with companies, just from a fundamental bottom-up process. In the UK, for example, we're part of the Stewardship Code, which is, fundamental principles include those things. So yeah, I think that the kind of rise of ESG investing as a trend has brought that to the fore, and we continue in our journey there.
Thank you. I think we're up against time. It's been a fascinating discussion. Thanks to everyone on the panel. Thank you very much for the interventions and questions from delegates as well. I think if people want to continue the discussion, certainly I'd be happy to, and I think we all would be happy to continue it over a coffee and throughout the day.
James and the panel, thank you so much. That was wonderful. I'm back. And while you take your seats, I would like to invite the rest of our guests and Your Excellency to take a short break. It's time for a coffee and a networking opportunity. So if I could ask you all to return to the auditorium for 11:40, that would be fantastic. I'll see